One of 2018, the size of the biggest conference. Esta yeri mañana, sura nyanya.
Presione. Yeah, we are ready to proceed. I'm told he's coming, he's on his way. You can raise the matter aside briefly.
You can confirm our position. We will be ready to proceed with 1 minute. Yes, sir.
kesi namba 8 of 2020 Jacob Mutambo.
Mother is coming for here. We'll be ready to proceed with the process.
Criminal case also of 2019. It is watching. What is Pengara? Miscellaneous criminal case number 6 of 2020. Public funds. First responder Rashid, Echesa. Daniel Kino Mundi alias Kino Clifford Court Boya alias Bo. Kennedy Oyo Boya.
Your Honor, in that matter, myself, yes, Your Honor, myself and Mr. Namasi and the married senior Mr. Onyek are in record for the suspect. Namasi, sorry, Your Honor. And Mr. Onyek are in record for the first suspect, Honorable Rashid Echesa. We have not been instructed by the rest of the suspects, unless they can do that now.
Please, the court, I'll be introducing the prosecution team. My name is Echesa together with Ms. Nora Otieno and Maureen Beleka. We are appearing for the applicant. The Republic. Your Honor, we are ready to. I'm verifying, Your Honor. application. Your Honor, can we? It's okay. Your Honor, this is an application. A notice of motion application. Voting under Article 49, 1GH of the Constitution of Kenya. Your Honor, the applicant in this matter is requesting that the respondents be detained by the applicant in lawful custody for 21 days at Muthaiga Police Station to enable the applicant conclude investigations. Your Honor, this application to enable the applicant to conclude investigations. Your Honor, this application is supported by an affidavit by PC John Munjama. And Your Honor, I'll be inviting the Honorable Court to peruse the whole affidavit because we are relying on it entirely. I wish to lay special emphasis on paragraphs 5, paragraphs 8, paragraphs 11, 13, 14, 15, and 16. Your Honor, it's our submission that the application before you is justified in view of the fact that the investigations are complex. There is need to get information from other government agencies as well as other private entities. Your Honor, we also wish to draw your attention to the fact that the investigators will need to travel outside the country particularly the United States of America to ascertain and establish the existence of an entity referred to as Eco Advanced Technologies. An entity referred to as Eco Advanced Technology. We have actually referred to it in paragraph 15 of the affidavit. Your Honor, some of the evidence that we intend to get from the United States of America will expect us to use mutual legal assistance. Your Honor, it's our submission that this process takes a long time. Therefore, the request of 21 days our request of 21 days is in our submission logical. Your Honor, it's also a submission that some of the evidence that the investigators intend to use is believed to be within the residences of the respondents. And if released, the respondents are likely to interfere with the investigations. We have also demonstrated that some of these documents were actually found in motor vehicles that belong to the respondents. This is just to confirm the fact that the reality is that some of the other documents or evidence are indeed likely to be in the residences of the respondents. In view of our submissions, as well as our application, the supporting affidavit, and Article 49 1G and H. I urge this Honorable Court to find that our application has merit. That's all, Your Honor. Maybe I could just find out if my colleagues need to add something. That's all.
Yes, Your Honor. Well, I want to start by saying that there are those fundamentals which the prosecution has to prove for you to be convinced to allow an application of this nature. Your Honor, for the record, we are opposed Yes, Your Honor, we are opposed to the application in entirety. And to begin with, Your Honor, the court must ask itself, for what reason will the first respondent, what reason will he, or has the prosecution advanced for him to be detained, for them to achieve whatever they want to achieve, as deponed in the supporting affidavits of the investigating officer? Yes, Your Honor. From the affidavits of the IO at paragraph 3, it is clear of the offense which the applicants are investigating. Very minor offense, Your Honor. The offense of making a document. Very minor and meaningless. That cannot call for the detention of the first respondent. It won't help investigations that he must be in custody for them to conclude investigation of such a minor offense. At paragraph 7 of the affidavit, paragraph 7, Your Honor, is alleged that the investigations are to ascertain the authenticity of various sensitive documents which are said to have originated from the Ministry of Defense. And I want to submit, Your Honor, ascertaining the authenticity of these documents sorry, Your Honor, last time when I worked with you were having a lot of speed, so I'm trying to catch up with you. It's okay. I know time has gone, but I will slow down. What I was saying, that as deponted paragraph 7 of the affidavit, ascertaining of these so-called sensitive documents do not require the presence of the first respondent in the custody of the police. At paragraph 11, Your Honor, the IO is saying that they recovered some documents hidden in the motor vehicles. Belonging to the respondents, and more specifically the first respondent. And our instructions, Your Honor, that no document was ever recovered from the vehicle belonging to the first respondent. KCR 786H. This KCR 786H. And Your Honor, if that had been the case, then the applicants have been brave enough, at least, to avail a copy of an inventory of whatever documents they recovered or allegedly recovered from the vehicle belonging to the first respondent. Just to follow that point, Your Honor, of that motor vehicle, we have no objection with the applicants retaining that motor vehicle for the time frame that they so wish, if they believe that that vehicle is an exhibit. We will deal with that later in the trial, if at all we reach that stage. So, Your Honor, the first respondent do not need to be detained together with motor vehicle, unless they want to detain him inside the motor vehicle. The same ringtone, Your Honor. So, Your Honor, paragraph 12:13, I don't want to dwell on that because I've not seen the reason that can convince this court to allow the detention of the first respondent. But I want to go to paragraph 15, Your Honor, and see the joke in this court. That investigations will necessitate, the investigators to travel outside the country. More so in the US. And Your Honor, in answer to that, now that, Your Honor, the first respondent cannot be held in custody for the reason that the investigators need to travel. And again, that simply shows Your Honor, it demonstrates that the arrest was actually done prematurely. Because the applicant is not even sure that this company called Eco Advanced exists. I'll end my submission, Your Honor, by attacking the legality or otherwise of the orders being sought. And I do so, Your Honor, in reference to the case of Michael Rotich versus Republic, (2016) EKR. Your Honor, I've highlighted the relevant page, that authority. That's the second last paragraph. That's the fourth line. The fourth line, the fourth sentence, starting with, as stated earlier in this ruling, the recent trend where a person is arrested and arraigned in court within 24 hours, specifically for the prosecution to seek extension of time to continue to detain such a person without any charge or holding charge being preferred against such person is unconstitutional. It is unconstitutional. That is the case here. The court went further to say the police have no authority nor to arrest and detain any person without sufficient grounds. Those grounds can only be sufficient if the police have prima facie evidence which can enable such a person to be charged with a disclosed offense. The fact that the prosecution has a prima facie evidence of a disclosed offense can be presented in court in the form of a holding charge, setting out the particular offense. Such holding charge would enable an accused person to know of the reason for his arrest as provided under Article 49(1)(a) of the Constitution. It will not do for the prosecution to present a person who has been arrested in court and seek his continued detention without a charge or a holding charge being lodged in court. It's unlawful for the police to seek to have a person who has been arrested to continue to remain in his custody without a formal charge being laid in court. And the court ends by saying, if this trend continues, it will erode all the gains made on the advancement of human rights and the fundamental freedoms as provided in the Bill of Rights. Your Honor, this is a 2016 decision of the High Court. And the same situation obtains here. We have no holding charge, we have no judge. But we are willing to give latitude to Madam Senior if he can present the charge sheet even at 2 p.m. or 3 p.m. So today is Valentine's Day, but my colleagues are willing to wait until around 4 or 5, so that we are in compliance with a binding decision from the High Court. My friend wants to add something.
Yes. Yes, Your Honor. My name, as earlier stated, is Namati James.
Yeah, I believe you'll not be repeating what you're putting at.
Exactly. The first thing I want to put before the court is that if you look at the section of the law under which the charge, these proceedings have been brought, and we are saying that the facts before you are not sufficient to invoke the court. Rely on that section to detain first accused person. My Lord, for the avoidance of doubt, the article reads, the accused person has a right, F, to be brought before a court as soon as reasonable possible, but not later than 24 hours at the first court appearance, to be charged or to be informed of the reason for the detention continuing, or to be released. There are 3 options, and we shall be requesting that you use the 3rd option. That is for the accused person number 1 to be released. There is no charge, as has been pointed out by my learned friend. There is no charge, as has been pointed out by my learned friend and as articulated by Justice Kimaru in the authority of Michael Rotich versus Republic. And there are no reasons this article should be invoked. So the court should exercise the 3rd link and release the first accused person. I've been listening keenly to my learned friend, Ms. Jacinta Nyamosi. She brings some reasons as 1, the investigations are complex. Donna, I have read the entire affidavit of the IO, John Munjama, and at no place does he deem this investigation complex. The affidavit is before you, have a chance to read it. But nowhere does he say these investigations are complex. That is a submission from the bar. And this court cannot rely on that to give the orders sought. Your Honor, the fact that the documents at paragraph 12, that more time is needed to have the documents verified by the Defense Ministry and Kenya Defense Forces. You know, my client does not work at the Defense Forces. At the moment, he's not even a minister. And therefore, the issue of the investigators checking with the Kenya Defense Forces or the Defense Ministry has nothing to do with my client. We don't need my client to be placed in custody for them to verify that. That can be verified when the accused person has been released as per the 3rd option. And when they'll get enough evidence, after verifying from the Kenya Defense Forces, and if they get any evidence against our client, then we can come back to court. That's if they'll get any evidence. But we are sure that no evidence exists as against the first accused person. There are allegations that some documents were found in 2 motor vehicles. First respondent, sorry. Your Honor, there are allegations that some documents were found in some named vehicles. There are 2 motor vehicles. Your Honor, no OB extract has been attached to confirm which documents were found in which vehicle. I know this is deliberate. It is to disguise as if there is something serious where there is none. When had any document been found in our client's vehicle, nothing would have been easier. Nothing would have been easier than this affidavit to attach that OB and an inventory duly signed by the officers who are on the ground and countersigned by my client, saying these are the documents found in KCR 786. IO is very experienced, and my friend Namosi is very senior and experienced in these matters. And if such a thing was there, we would be seeing it attached on this application. The fact that it is not here clearly indicates it is nowhere. And this is a ploy to hold our client hearing for unnecessarily long to achieve whatever motive the IO are having. The investigators traveling, my line friend has already touched on that, I'll not repeat. The existence of the company in USA. You know, this is a digital era. we are all in the digital space. We are now in the artificial intelligence stage. If you want to know the existence of Eco Advanced Technologies, LLC, in an advanced country like the USA, nobody needs to travel to the US. Nobody. Even us in Kenya here, we don't need to visit the company registry to know who the directors of a company are, because this is a limited liability company, LLC. So the existence can be established at the comfort of a computer of the investigation office. So for that reason, Your Honor, we are saying these orders shall not be granted. Rather, the court should at this stage order the accused person, the respondent number one, to be released forthwith, as there is no ground for him to be held for any other single minute, at least as per what we have before you.
Your Honor, my colleagues,
you also three. Three ladies. Three against three.
I'm not going to repeat anything, Your Honor, except I associate myself with what they have said and add the following. If you look at the notes of motion dated 14th February 2020, Valentine's Day, the request, there is no request in that notes of motion to do a search, either of the vehicles or of the houses of the subjects. There is no request. So, Your Honor, when the argument in the affidavit that they want to do further investigation, they have started an unlawful process because they never sought warrant from the court to search. They want to continue with the illegality by using the court process now. Your Honor, I urge the court to reject this request because there is no prayer for a search. Yes, there is no prayer in the notes of motion, Your Honor. Prayer 1 is to certify the application and hear it inter partes. Prayer 2, the response. Your Honor, it is even the respondent. We don't know which one they want to detain. Whether it's the first, second, or the respondent. They are just saying the respondent be detained. Which one do they want to detain? Courts of law act on clarity. the prayer sort are not even clear on what they want. Then, Your Honor, they want 21 days. I want to interrogate that constitutionally. Then no orders to costs, and that the application be allowed. Your Honor, let us get serious. This is very pedestrian.
Right.
We want to be very honest with you.
Get him right.
Yes. Your Honor, the subjects are Kenyan citizens. There's no dispute. Your Honor, the subjects under the Bill of Rights in our Constitution, where the preamble says, in what we trust, and we give ourselves to the Constitution. What is this Constitution, Your Honor? Number 1, Article 19(3)(a), that the rights and privileges enjoyed by the subjects are not privileges by the state. They are privileges to the individuals, the subjects. And Your Honor, these are not favors. Oh, sorry. So, Your Honor, under the preamble, and Article 19(3)(a), these rights are not privileges by the state. They are fundamental rights and freedoms enjoyed by the subjects.
Inherent.
They are inherent. They are sacrosanct. Your Honor, it is in very exceptional circumstances where the state has demonstrated prima facie that there are facts which are tangible, which are consistent, that the fundamental rights and freedoms can be breached or be limited. Nothing like that has been demonstrated to this court. Your Honor, I will take you to Article 25(c). I'll take you first to Article 21(1) of the Constitution before I take you to C, 25(c). 21(1) of the Constitution, Your Honor, obligates all individuals, state organs, and state agencies, and the applicants are state agents, to observe, promote, protect, and fulfill the constitutional provisions. You know what does that entail? It entails that if they carry out investigations, they must be open, they must be transparent, within the meaning of Article 10 of the Constitution. The integrity of that process must be beyond question. When they come here, Your Honor, and they want to detain the subject for 21 days, not 2 days, not 3, not even 4, 21 days, 3 weeks. 3 weeks, Your Honor, a hen which has laid eggs will hatch the chickens. Because we have to contextualize the period they want. It's not just the days. It means a hen with eggs will emerge with chickens after 21 days. That is how serious this is. That's how serious we must take it. So we cannot take these things for granted, Your Honor. We submit that act and that request violates those constitutional values and principles which they are obligated to obey. Yes. Your Honor, will go to Article 25C, fair trial. Your Honor, fair trial is non-derogative. It cannot be limited. And we submit that where the investigations start on the wrong premise, like this one of detaining subjects for 21 days, then the principle of fair trial is compromised. It matters not what we do thereafter. And I submit that because of that reason, Your Honor, you should reject this application. Your Honor, I'll take you to Article 27(1) of the Constitution. Your Honor, Article 27(1) obligates the court under the DPP and investigations to protect the subject's rights and give them full benefit of the law. Your Honor, where is protection if you can be detained for 21 days? That they want to go and cover some things. Where is that protection? It will beat the purpose. Oh, sorry, Your Honor. Allowing the application, Your Honor, will defeat the purpose of that constitutional provision, protection of the law, and the full benefit of the law. Your Honor, you can't get full benefit of the law where you have been put behind bars for 21 days to allow police officers who are being paid their salaries by your taxes to go and carry out investigations. That is an abuse of the process. If they have evidence, they should bring and charge. If they don't have evidence, they wait and gather the evidence. Your Honor, I'll take you to Article 47.
Migration services. That's why he said he always in this court. That one brings him in this court always. Yes. All the time.
Your Honor, I'll take you to Article 47, 1 and 2 of the Constitution, where the Constitution obligates the applicants that where there are actions, and particularly administrative actions, where they are dealing with investigations, is likely to affect the fundamental rights of the subjects, then they are supposed to do a letter to them and warn them that we are investigating something about you and we are coming, we need certain documents, we need certain things from you. Yes. Your Honor, I've looked at the application, which my learned colleague have analyzed critically. I have not seen any attachment of a letter to any of the subjects demanding for certain things, which they have refused to comply. So, Your Honor, this is another violation of the Constitution and also a violation of Section 3, Section 4, and Section 5 of the Fair Administrative Act 2015, which obligates the police. Oh, sorry, Your Honor. Your Honor, I submit, and we submit, together with our colleagues, that these constitutional provisions are not just paper aspirations. They bind us, all of us. We must obey them. So, Your Honor, that's why we are saying Article 47(1) and 2 have been violated because no correspondence has been annexed demanding from the subjects that they want certain things. We do submit also that violates Section 3, Section 4, Section 3, Section 4 and Section 5 of what we have recorded. So, Your Honor, what are we saying in few words? We are saying that constitutional provisions must be obeyed at all times by all of us. They are not just on paper. It is the parent law of this land. There is no need of the police complying with the regulations, but they are violating the Constitution, which is the parent law.
Dear friends,
Your Honor, I want to give the historical context of Article 49, 1G, 1G and H, so that we appreciate why did the Constitution specify 24 hours. Your Honor, before the enactment of the Constitution 2010, the police sometimes could hold suspects for 8 months. They could arrest them and forget about them. And this was well ordained in Arbanas Masia Mutua versus the Republic. Criminal Appeal number 202 of 2004. Where, Your Honor, the suspect was kept in custody for 8 months. He was literally forgotten. of 2004, Court of Appeal decision, Arpanas Masia versus the Republic. The appellant was acquitted because of that day. It was unusual, it was unconstitutional. Your Lordship, Your Honor, when people gave views, they wanted specifically the 24 hours be protected to avoid such abuse. That is what brought the provision of Article 49, 1H. Specifically 24 hours. Your Honor, our argument is this. If the constitutional threshold is 24 hours, the constitutional measurement of reasonable time after arrest is 24 hours. Let us agree that there are exceptional circumstances where my learned colleague Jacinta is taking somebody's coat but the vehicle breaks down and it is 4:40. So she is unable to make to court within 24 hours. That is a reasonable explanation that or the driver dies of heart attack when taking the suspect to court. So she has to look for another driver. What forbid? I'm saying that there could be exceptional circumstances when the state can come now and say, Your Honor, we can't meet the 24-hour rule because of some exceptional circumstance. We want one more day. That is acceptable, Your Honor. That is reasonable in a democratic society. But where they are coming to seek 21 days, 3 weeks, so Your Honor, we are saying where the Constitution prescribes 24 hours, and then they come and seek 21 days. Your Honor, in real terms, they are seeking 504 hours because each day has 24 hours times 21. That brings us to 504 hours. Your Honor, that's a lot of time. In terms of constitutional measurement, Your Honor, we submit that that is unreasonable. Because that was never the intention of the drafters of the Constitution. That's why they limited it to 24 hours. Why, Your Honor? They did not want abuse of the process. Now, I want to demonstrate why there is abuse in this case, Your Honor. There is malice. They wait until Thursday in the evening.
Denied access, the family not access, given us some denied access.
And then they arrest the subjects. They know very well that the following day is Friday. They come out with a miscellaneous, strategically miscellaneous application to request for more time. Already, Your Honor, they know that by God's grace, they have Saturday and Sunday, which do not count. That means they want to ask for Monday next week. You can see obvious malice. Deliberate. You arrest on a Friday, you seek more time. Why didn't they arrest him on Wednesday? I know Wednesday was a special day. Our former president was being buried. It was and the previous day was a holiday. Why didn't they do an arrest? So those are questions, Your Honor. When you interrogate them, you realize that it's malice. The second malice, Your Honor, the first respondent. Sorry. So Your Honor, we submit that there is malice. The timing, the day, and the number of days requested demonstrates malice. Secondly, Your Honor, the second abuse. The first respondent has taken a different political view about the debate between PPI and the way we are going.
I would kindly request my colleague not to bring any political angle over here. I do not align myself with any political side or anything. Please,
they will respond. They will respond. The first subject is a former minister. He held a meeting at Mumias where he articulated certain political ideologies. That is the reason why he has been arrested, because they want to silence him. They want him to submit to a particular political doctrine. So, I submit, Your Honor. No, let me submit, they will respond. They have time. I submit, Your Honor, that. Okay. I'm ready to take the witness box because it is well documented. I can even Google it. Like the meeting took place. But all said and done. Okay, let me leave that. Let me submit on a different issue. Rashid, I need to submit that I'm submitting on the political doctrine. Yeah, I know. I'm submitting on the political doctrine now. And then my submission is as follows. Kenya is a democracy. And this is in Article 20 of the Constitution. Kenya is a democracy. And even in under Article 24, where a right is supposed to be limited. So, Your Honor, under Article 24, 2 and 3, even where you limit a right, you cannot limit it to the extent that you deviate from its minimum core content. Kenya is a democracy, and in a democracy we have freedom of speech. And I submit, Your Honor, that the subjects have freedom of speech to say anything they want, so long as they respect other people's rights. So, the state organs, particularly the DCI, should not be used to persecute the respondents just because of their perceived political views or opinions. That will be unconstitutional. If they have facts about any criminal act, they can provide evidence. And based on the evidence, the court can decide either to admit the charge or commence a trial. That is fair. Finally, Your Lordship, Your Honor, finally, Your Honor, Article 157(11) of the Constitution prevents or contemplates three things which the DPP should not do. He should not engage in a prosecution that is for a purpose other than achieving a criminal justice system. That's number one. Number two, is not engaged in a prosecution
That would be the ends of justice.
of a case that is not meant to pursue or to further the interest of justice. In other words, he must always act in public interest. Number two, criminal prosecution should not be pursued in abuse of the powers donated by the Constitution. And finally, criminal prosecutions should not be used to resolve either perceived or unperceived disagreements. Your Honor, we want the respondent to tell us what is it that they have against the first respondent that is so serious that hii mtu atawezi rara hata kwa nyumba na peace, anasturiwa. What is it? They should say it so that we know it, then we can be able to know there is a problem. Mr. Echesa, can you change your course? But for nothing, suspicion, your Honor, suspicion can never be the basis to charge suspects in court. Charges in court are serious issues that are based on tangible evidence. Finally, Your Honor, to recap what my learned colleagues have said, and I'm happy they captured everything, but my learned colleague Namati said that actually in this digital age, I've just Googled about this company. It is here. It is based in Chicago and it deals with energy, security, and other issues. So I'm asking, why should we take 10 officers to Chicago? And one officer spends about $2,000 an air ticket. That is about 2 million shillings. Just to go and see what we can Google here for 1 shilling. And it has brought me all the information that I want about this company called Eco Advanced Technologies LLC and what they do. And they have listed what they do here. They have not hidden it. So, Your Honor, some of these things, it is common sense. What they are submitting doesn't make sense. Even Wanjiku, Moraa, and Nafura, who enacted this constitution, Your Honor, they know that you don't need to travel to America to know whether this company exists or not. Now, Your Honor, secondly to that limb of argument, ordinarily, from the facts deboned by Mr. P.C. John Munjama, it looks like the complainant is this company. Your Honor, no statement, no affidavit from this technology. Your Honor, if you look at the paragraph 15, our argument is twofold. Number one, they have not attached any evidence from whatsoever from Eco Advanced Technologies LLC to show that they have complained or an affidavit to that effect. Nothing. But to add insult to injury, they are even casting doubts about the existence of this entity. Your Honor, how can we subject these senior citizens into serious investigation before prima facie we do a basis that this company exists? And who is to provide that evidence, Your Honor?
It's like they want to shop for the complainant. Yes. And to go and shop for the complainant.
So, Your Honor, this is an attempt, and that's where, Your Honor, we are submitting that we must stop it on its tracks. This is an attempt to go and shop for complainants. And Your Honor, I've seen there are 10 different companies in the US with this similar name. The only difference is that either there is an LLC or one is based in Chicago and another one in Texas. So now they want time to go and shop for complaints, to go and shop for affidavits, and to go and shop for evidence. Your Honor, why did they arrest if they didn't have evidence? Our submission to this court, Honorable Court, Honor, is that the court should never Your Honor, under Article 60, this court is independent and impartial, and it should never allow itself to be used as a forum to launch investigations into suspects. This court, Your Honor, deals with a final product, That is why there is the doctrine of separation of powers. They do investigation. Oh, sorry. Let me start like this. Under Article 160 of the Constitution, this court is independent and impartial. And then it should never allow itself to be used as a forum to assist in investigations of crime. As a forum to assist in investigations of crime. Your Honor, the doctrine of separation of powers. The doctrine of separation of powers, Your Honor, separates these institutions. The judiciary adjudicates cases, the executive investigates, and the parliament legislates. There was wisdom why these powers were separated, to create checks and balances, to create accountability, to create integrity, to create an open process. Your Honor, I rest my case by urging you, and I know you are wise, to reject this case in total, this application. And in doing so, Your Honor, I urge you to rely on the case of Michael Rotich versus Republic, which my learned colleague has given you a copy, which lays bare the legal and constitutional principles. Your Honor, Kenya is a signatory to international conventions and treaties, which makes it a legal practice. Your Honor, in Malawi, last week, they quoted a Kenyan case to nullify their elections. That means, Your Honor, people respect us because we follow the rule of law and due process. So, Your Honor, in accord with those international good practices, I urge you to reject in total the notice of motion dated 14th February 2020 and admit the subjects to reasonable bond, let them do investigations, let them enjoy their freedom. Once they make up their mind if they want to charge, they will come and charge, we'll deal with it. But they cannot hold these people in custody just to go and do more investigations. We rest our case.
These are very formidable team. Tunajipatia sections. Hapa. Unaona? Chini yao.
And also just concur the learned colleagues of Kenya that you reject the whole.
Yeah, sasa si fitina imekwisha. Fitina imekwisha. The fitina, my friend, if you look at the inventory of the police, there is nothing which was recovered in my vehicle. My arrest has been politically instigated, and this is pure politics. Yeah? Yeah. So, law is clear, as the court have said. I've been granted a bond of 1 million Kenya shillings, of which I pay on Monday, and be released, pending investigations. But Kenyans now can see what is happening. People are using our police officers in a bad way. You arrest someone without even an offense, then you peddle lies, you know.
It's 39 billion.
Which 39 billion? There's nobody who is complaining that I have obtained money from him. No one. Nothing has been found in my vehicle. If you look at the inventory of the police, there's nothing. Absolutely nothing.